Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
How can criminal tax defense counsel protect you if you have a history of committing tax fraud and are faced with a divorce? Criminal tax defense counsel can help you. If you've got a history of committing tax fraud and you find yourself faced with a divorce scenario, whether you intend to get divorced or whether you find out you're being divorced, and you've got a history of committing tax fraud, how can someone like myself protect you and make sure that the damages from your past behavior are minimized and you're not incarcerated for it? Okay? Believe it or not, there's a strategy and it works. First of all, criminal tax defense counsel has to determine very early in the divorce scenario whether the risk of criminal tax prosecution has merit. I have to look at the tax returns. I have to look at the accounting. I have to look at all positions taken on payroll tax returns, sales tax returns, whether you have independent contractors that are illegal aliens. I mean, there's a multitude of ways that you could have committed tax fraud in your life, and what I've discovered is people who commit tax fraud usually commit tax fraud across the board. They have multiple areas of exposure. Federal liability, state liability, lots of different ways where the BOA could be coming at you, the Franchise Tax Board could be coming at you, the IRS could be coming at you. Believe it or not, there's a way to fix it all, okay? And I'm going to explain that to you. First of all, if I determine that the risk of criminal prosecution has merit, I find all sorts of badges of fraud in your fact pattern. I'm able to pick apart the tax fraud you've committed because I can read a general ledger like a fish. I look at your accounting, I can tell I'm looking at cookbooks. I look at the positions taken on the return, I can tell they wouldn't withstand merit if they were audited or you were criminally investigated. I can tell you whether you have criminal tax exposure. Matter of fact, the person who really knows is you. You know you've committed tax fraud. It's hard to do that without knowing you've committed tax fraud. Bottom line, you can close the door with me and say, Dave, I've committed tax fraud and I'm facing a divorce. How do I deal with it? Or if you don't want to make that admission, frankly, you should. I can't protect you unless I know where the bodies are buried. I'll go in and figure it out myself. My staff will figure it out. Everybody that works for me is either an attorney or a Covell accountant, an accountant working for an attorney, therefore they're subject to attorney-client privilege. We'll figure it out. The divorce should not proceed until the criminal tax exposure is mitigated. What do I need to mitigate against? Okay. One spouse turning government informant because of revenge-seeking behavior. My father, who was divorced by my mother, once told me that you can't truly hate somebody unless you once loved them. I understand what he was talking about. There's another saying, hell hath no fury like a woman scorned. I've literally dealt with situations where the spouse didn't care if there was a lick of money left in the marital estate. All she wanted was revenge for the pain the husband had caused her, and literally drained the estate of every nickel and didn't care. It was about revenge, and that made her happy. The more unhappy her husband was, the happier she was. That's just how she was wired. There's also a danger that a deposed tax-cheating spouse is likely to attempt to cover up past indiscretions involving tax fraud when they're under oath. Guess what? If you lie under oath, that's perjury. Also, that record may be public and the IRS may be reading it. I'll get into some case law where that's happened before. You may say something that's going to shed light on the false statements you've made in prior fraudulent returns when you're being deposed. Okay? That's another danger I need to mitigate against. What you really need to understand is that the mandatory public disclosure that takes place as a result of a divorce, specifically the divorce discovery process, can result in a loss of your Fifth Amendment privilege against self-incrimination for any documents you produce in that divorce. Two of the strongest privileges that a criminal tax defense attorney can protect is the Fifth Amendment privilege against self-incrimination, the Fourth Amendment privilege against unreasonable searches and seizures. Once a document goes into the public divorce record, I can't protect it from discovery in a subsequent criminal investigation. I've said this before, I'll say it again. The IRS is known to monitor the court documents looking for accusations or indications of tax fraud. These are the things I'm trying to mitigate against. What else am I trying to mitigate against? All right. Well, when your wife or your husband goes out and hires a forensic accountant because they believe that you've been cheating on your taxes and hiding income, or they believe you have undisclosed foreign assets in foreign accounts, or you have a business offshore that you didn't report, or that $5 million inheritance that came in from your relatives in China that you never brought into the United States, that you've never reported for tax purposes or estate purposes, never did a 3520, never did an F-bar, never reported the income off of the $5 million that you've got invested in a foreign market, never reported the dividends, the PFIC income, the interest income, the capital gains, all of that investment income. That entire behavior is fraudulent, and the government is all over that. So here's the biggest risk. The forensic accountants and other eyewitnesses involved in the divorce may come into the possession of incriminating documents or information and later on be forced to talk to the taxing authorities, whether they want to or not, because they don't have attorney-client privilege or work product privilege. They must talk to the taxing authorities, or there'll be a court order throwing them in jail and not releasing them until they do speak freely to the taxing authorities. Again, the possibility of damage to the credibility of the tax cheating spouse with the divorce court. It's very hard for you to stand up in front of the divorce court and be seen as an honest person after the divorce court realizes that you're a tax cheat and you've been lying about it. You'll have no credibility, and every decision could go against you because of it. If evidence of tax crime surfaces during the divorce, or your wife makes an innocent spouse claim, or your husband makes an innocent spouse claim, actions that you take subsequently may be viewed as corrective actions of a tax cheating spouse and viewed as non-voluntary, and thus kill the availability of a potential pass on criminal prosecution, which is the whole goal of what I'm trying to achieve once I try and fix this for you. Again, I need to mitigate against the fact that evidence of tax crimes exists forever in the public divorce court records, and there's no statute of limitations on tax crimes. Okay? There's a criminal limitation, 6 years, 5 years, depending on the law. But the underlying tax fraud can be got at any time in the past if they discover tax fraud during an open tax year. Any of the investigation years the statute is open, they can go backwards. I also need to mitigate against the fact that the judge themselves or their staff or any third party that happens to be in a courtroom when evidence of tax fraud comes percolating up to the surface doesn't go to the taxing authorities seeking a whistleblower award. Right now, you can obtain between 15 and 25% of whatever the government squeezes out of the hide of a tax cheat just by reporting the tax cheat to the taxing authorities. Courtroom people know this. Now, the judge isn't going to do that for monetary purposes. If the judge turns you in, it's because he believes he has a moral obligation to do so, and possibly a legal obligation to do so. We'll get into that a little bit later. What could they be looking for? Anybody in the gallery of the divorce court? Anybody on the staff of the judge, the divorce judge? They could be looking for a whistleblower award. Simply by reporting that you've committed tax fraud, and they know it, they can get between 15 and 25% of the underlying tax fraud. That's a hell of a lot of motivation to rat you out. So, most important thing for me to do as criminal tax defense counsel is identify any risk of criminal prosecution as early as possible. I want to be your first phone call if you're facing a divorce and you know you're a tax cheat. It's the only way I can protect you. The more people you talk to, the more people your wife talks to, the more likely this thing is to slip out of the bag. Bottom line is, to fix this, I need to get to the government and self-report your tax fraud in something called a domestic voluntary disclosure and fix it voluntarily before the government gets information on your tax fraud from a third party. If they get the information on you first, you go to jail. If I get there first, you don't. Okay, so how do I mitigate this exposure? First of all, a forensic accountant should not be hired if there's risk of criminal prosecution until the criminal tax issues are resolved. Let me explain why. Furthermore, forensic accountants don't have attorney-client privilege where they're employed to provide expert testimony in a divorce. Most of the time, that's why a forensic accountant is hired to testify in front of the divorce court. The documents created by a forensic accountant, they don't constitute privileged attorney work product because they're prepared in support of an expert's testimony at trial, and therefore they're discoverable. Once read into the record, they're part of the public record, and the government can discover them. Any documents that are provided to a forensic accountant will lose Fifth Amendment protection. If the risk of tax fraud in your divorce is high, if it has merit, you need to hire experienced criminal tax defense counsel. If that's not me, someone like me. If you're not impressed with me, call me. I got lots of other people I can refer you to. You need to be advised how to handle this. And then I have to supervise the conduct of a tax investigation using a Counsel accountant to assess the risk of tax crimes having been committed and to mitigate your exposure. Someone that works for me, that's a CPA, an EA, an accountant, they work for me. I'm a law firm. They're employees of a law firm. I'm providing a legal service, which is determining whether a tax crime has been committed. I can protect your attorney-client privilege by using these people. As long as my firm doesn't prepare a tax return, that privilege is protected. We can figure it out. A Counsel accountant is an accountant that's hired specifically to help an attorney render legal services to a client. Okay? Counsel comes out of a case called Counsel versus the Commissioner, where a criminal defense firm had hired an ex-IRS employee to help protect their clients that were going through tax investigations. And the IRS decided, well, you're not an attorney, you're ex-IRS personnel. They let him work there 6 months, and then they went into federal court and subpoenaed this ex-IRS employee to come testify. And this guy actually went to jail for a year because the judge demanded him to testify. The attorneys that he was working for demanded that he keep his mouth shut. He sat in a jail cell for a year while this went up to an appeals court. The appeals court found that the accountant, the IRS ex-employee, had attorney-client privilege just like the attorney did because he was providing a legal service for the attorney. Therefore, they had to let him out of jail, and nobody else risked that because of this person that went to jail for a year. My staff is grateful to hear that. Again, a Counsel accountant should not prepare tax returns because returns are public disclosures, just like attorneys. Even if an attorney prepares your tax return, that tax return is a public disclosure, and no attorney-client privilege attaches to a document prepared to be a public disclosure. Therefore, even an attorney preparing a tax return will not render work product or attorney-client privilege to the information that went into a tax return. A single criminal tax defense lawyer should ordinarily not represent both spouses in mitigating criminal tax issues. Now, if the divorce hasn't happened yet, if the parties are able to hold hands enough to do what's called a domestic voluntary disclosure, and they're willing to sign a conflict waiver and hold off with the divorce until the tax crimes have been cleaned up, one attorney could probably do that, represent both parties, okay? What also could be done is if husband and wife each want their own divorce counsel, which really should happen in most circumstances. It would be a rarity where one defense counsel would do both. A joint defense agreement can be entered into between both husband and wife. Therefore, there'll be preservation of communication of work product privileges where the husband and wife and their tax counsels work together as a team to protect the couple from the tax fraud that's taken place. Bottom line here is conflicts of interest between husband and wife are inherent in a divorce scenario. One spouse could say, I'm an innocent spouse, I didn't have anything to do with it. One spouse could try and make an innocent spouse claim to bury the other one. The evidence could point all to one spouse committing all this fraud, even if both of them were involved in it. The bottom line here is divorcing spouses ordinarily will have differing levels of knowledge and perceived culpability concerning past tax crimes. Even if husband and wife hold themselves out to be equally culpable for the tax fraud, any available evidence to indicate that tax fraud has occurred may not be equally incriminating between husband and wife. And all it takes is either husband or wife to change their mind later on.
Thank you so much again for your time and interest in how we may be able to help you. Please don't hesitate to call if something is worrying you. We would be very happy to help. Just call or email for a reduced rate consultation.